Well, thanks for sitting down with us. We appreciate it.
Yeah, happy to.
So I want to start off with a question that I actually get a lot from people kind of asking, especially in the Madison area, with this idea of the fake electors. We've seen certainly other states like Arizona issue grand jury indictments against their slate of false electors. Where are we with that in Wisconsin?
Well, first, I think anybody who committed a crime with the goal of overturning the results of a presidential election, or any election for that matter, should be held accountable for those actions. And I know that this is an issue that people across the country, including my colleagues in other states, and Jack Smith and his investigation and for the U.S. Department of Justice, take incredibly seriously. We don't comment or confirm or deny the existence of ongoing investigations in Wisconsin, at least that DOJ may be involved with. But ultimately, I think it's critical that if folks committed crimes, they're held accountable for their actions.
Not to confirm a potential investigation that may be going on, what kind of timeline would we see that? Would we expect something soon?
Again, we don't confirm or deny the existence of ongoing investigations. And I can also say generally that with any investigation, the timeline can vary widely depending on facts and circumstances. And so, not much I can add beyond that.
Certainly. We've also seen the State Ethics Commission refer charges against a couple of people, including state legislators, for kind of steering funds kind of against state law. Do you have any sense of whether the DOJ will step up and commence prosecutions there at all?
There's sort of a unique process for referring cases in that context. The Ethics Commission can make referrals, but they go to DA's offices first, and then they can come to DOJ after that. And that process is playing out right now. So we'll see what ultimately happens with the referrals, and what we do or don't do will depend both on what gets referred in total and then also on the facts and law of that case. But as with any other issue, we take potential violations of our election law seriously. And so if there is information that indicates there's a violation of law, that's something that we would take a very close look at.
And just kind of nuts and bolts, is that something that a local prosecutor would have to ask DOJ to step in, or can you just do it on your own volition?
This is a somewhat unique context. The statute for Ethics Commission referrals is set up so that those referrals, if they're not prosecuted by a DA, can then be referred from the Ethics Commission to DOJ. In a lot of cases, it's the local DA who has authority to prosecute, and for DOJ to prosecute, we would need to be asked. But in this context, there's a specific statutory scheme for these types of violations.
Got it. Also understand that you're asking the state Supreme Court to revisit the Dropbox issue. What do you think will be different now? What legal pathway are you pursuing for that?
Well, first, we think there are some significant developments that have happened in the last few years. When the Supreme Court ruled that Dropboxes couldn't be used in Wisconsin, that had some impact on the accessibility of voting for folks. And I don't think it does anything to promote the safety and security of our elections. If you just think about it, you can put your ballot in the mail and leave it there. It then goes through the hands of the Postal Service. It may or may not get delivered on time. Hopefully you've put in the mail early enough to get it there on time. A Dropbox, on the other hand, could be right next to the mailbox. It's a secure system, and there it doesn't go through a third party. It just goes directly to the election officials who pick it up, and that way you know it's going to be received on time. So there's no logical reason we shouldn't have Dropboxes, and I think having no Dropboxes for the last election just reaffirmed the point that there's no reason for this, and we argue that this is inconsistent with state law as well. So it's my hope that the court will take another look at the statutes and conclude that the use of Dropboxes is lawful, and that it'll be part of what we have to make sure our system of elections is safe, secure, and also accessible.
So we've seen a lot of these lawsuits, Dropboxes, abortion, for example, make their way through now liberal Supreme Court. Obviously, you're sitting Democrat elected statewide. We also could see the court change as early as next spring or next August, once the justice would be seated. Do you think some of these kind of big name cases will be able to work through the court system in time for liberals to avoid possibly a change next year?
Well, certainly nobody knows what's going to happen with the court system, in the years ahead. But first, I think it's important to note that I think both the court and certainly our office take cases based on the facts and the law. And of course, different justices are going to view certain issues differently. But on a number of issues, you'll see surprising alignments of justices. And in some cases, the cases were filed with one set of justices on the court and they're continuing. So take the abortion context. We filed that lawsuit 4 days after Dobbs was overruled because we wanted to fight to restore access as quickly as possible. At the time, there was a 4-3 conservative majority on the state Supreme Court. Now that's shifted over time, and we've asked the state Supreme Court to take that case up. But it's a good example of how it's often more complex than just counting the number of votes on either side of a case. But I do think the court's going to weigh in on some important issues. We've of course had a ruling on gerrymandering already. I was proud to be one of the lawyers representing the governor in that case and fighting for fair maps. We've asked the court to take up abortion, and they recently heard a really significant separation of powers case that could have a big impact on the ability of executive branch agencies to put rules in place to protect Wisconsinites.
Earlier this week, we saw the Federal Trade Commission issued their ruling that non-compete clauses would be unenforceable. Just a general sense of like how that would impact Wisconsinites here.
Well, we'll see how broadly it impacts Wisconsinites, but it's definitely going to have an impact, and from my perspective, a positive impact on working families in Wisconsin. One of the things we've seen with non-competes over the years is that they've gone from specialized contexts, like somebody who might have very specific knowledge about trade secrets or something where going to a competitor might create an unfair advantage, to these being used really broadly in a lot of different industries in a way that prevents folks who are working at different companies from seeking out a higher wage at a competitor. What that leads to is lower wages for working families. It leads to higher prices for consumers because there's less competition in the marketplace. And the big, powerful corporate actors are the ones who are benefiting from this. So this is another example of the Biden administration stepping in on behalf of working families here with a policy that's going to make a big difference. Now, I expect that there will be legal challenges to this. There are with many, many rulemakings. So the process remains to play out. But this change is good for consumers, and it's good for working families.
And I also understand that you're pushing for expanded protections for IVF. Are we in danger of seeing any restrictions on that procedure here in Wisconsin, or is there just a general need for that across the country?
Well, we're in a really fluid environment with respect to reproductive rights right now. I think if you had asked people 4 or 5 years ago if the basic protections of Roe v. Wade were about to go away, a lot of people would have been skeptical of that. And yet here in Wisconsin for over a year, there was virtually no access to safe and legal abortion, which is why we brought that lawsuit and fortunately have restored it. But that case is still going through the courts. The Alabama Supreme Court's ruling put IVF at risk in the long term in that state and caused facilities to stop providing services. And some of the arguments that underlie that are ones that could be raised in other places where there's this argument that fetuses should be treated legally exactly the same as people. That has all sorts of potential legal consequences, one of which is that IVF may become available. I think it's vital that any family that wants to grow their family by using IVF or another assisted means of having a baby has access to that. This has made a huge difference in the lives of so many families, and the idea that we would see it banned is really, really concerning. So having federal legislation in place that guarantees that IVF remains available in Wisconsin and in other states of the country, I think is common sense, and it's unfortunately needed given what's happening around the country.